I believe we're good and live.
Happy Friday, everybody.
Happy Friday. Pete, are you ready to give us an update?
I am. So this really comes from a handful of emails that we've received over the past week. Hey, what's going on with the Second Amendment cases? It seems like you're focusing on, like, for example, the Linebarger right to petition and free speech. You're looking at medical freedom. Are you guys still doing these types of cases? So I want to first dispel the notion that, no, we've not moved away from any of our particular cases. And second, I really want to try to give an update on as many of the cases as I can recall as possible. There may be some that we miss in the cracks, but I figured I'd just kind of go through a list of the cases that we're actively litigating right now and provide a quick update. So I don't think this podcast will be as long as some of the other ones. But I do intend it to be informative and making sure that people know that, yes, the work that you're funding is being done. We might not have some immediate action today, but there is in many cases, imminent forthcoming action that could really impact your civil rights. So with that, I'm going to start with Peace Health. For anyone that forgot about that case, we sued Peace Health on behalf of, I think, like 65 plaintiffs, nurses, primarily nurses, and then some support staff, like the janitorial type staff and other kind of boots on the ground workers. And we alleged that these individuals who were placed on long-term leave without pay, and some of whom are still on leave without pay, they're not fired. Peace Health doesn't want to fire them. They want to try and keep them on this like dark payroll without paying them. Some of these people have had vacation cashed out. They've lost their benefits, and they've basically been told, yeah, you're welcome to reapply for your job. And in some instances, many instances, the jobs aren't available. In some instances, we have one woman who had both a medical and religious exemption she sought, and the same job is available at the same facility, yet they're barring her from applying. And so Peace Health, we had what's called a motion to dismiss filed by Peace Health, and they were seeking to, it is what it means, it dismissed the case, no more discovery, no more facts, like, bam, thanks for trying, get out of here. That was filed, I think, in early spring, and we've even provided supplemental briefing from the United States Supreme Court. There was a case called Groff versus DeJoy, and that was a case where the United States Supreme Court held that the de minimis requirement, the threshold of providing exemptions, meaning an employer wouldn't have to suffer the de minimis cost, any minimal cost was adequate. We briefed that case up. Unfortunately, right after we briefed that case up, the case got transferred to a new judge, and so she's been sitting on this for about 4 to 5 months.
Wow.
Yeah.
So timeline-wise, I ask you this all the time. What do you think could possibly happen with that case? How long are we going to be waiting? Is that indeterminate? Is it who knows? Is there a statute that they have to reply by a certain amount of time?
No, not in federal court. So this is in federal court. So you're really at the whim of the judge. And we saw this with our Brumbeck case, and we'll talk about that one, where the judge had it for like 9, 10, 11 months, I think, and then issued a decision. I guess it was about 9.5 months. And so, I always say this, I kind of expect to see a decision come across every day. Every time I get a notice in my email, there are very specific notices of court cases, and they title them by the number, and I don't remember which one's which number. I know them by name, and it's like I kind of hold my breath to see what it is that's coming at me, right?
Right.
And so, unfortunately, this case is yet to be decided, but I do anticipate that if we're successful in defending against this motion to dismiss, that's really going to open up the conversation as to whether or not Peace Health wants to settle. So, that's that case. So it's live. We're not actively doing anything. We're preparing. Karen and I talk about discovery options often. What if this happens? What if we survive the motion to dismiss and Peace Health just wants to go into discovery, which I really don't think they want to.
Right.
But we're getting ready just in case.
So are there any far-reaching impacts you think will come with a positive settlement or positive result from this case?
The settlement, the impacts would be limited. You know, I mean, this is the issue where we've seen cases like this settled, and everyone's like, "Oh, we'll win," and it's like, great, it's a win, but now it's not a binding precedent.
Right.
We saw that the New York workers got reinstated from the New York Supreme Court, and I want to be very clear that that's not our Supreme Court. Not in the sense that we don't live in New York. I think everyone knows that, but there the Supreme Court is a lower court.
Right.
And so it's not as binding as it would be if it were, the Washington State Supreme Court. Like that would maybe have a little bit further reach.
Mm-hmm.
So it's a lower court. It's no different than like our district or our superior court.
Gotcha.
And so with that, I think this case, especially if we get a decision on the merits, it would have tremendous impact. Obviously, a decision against Peace Health on the merits, down the road after discovery, like a full-on jury verdict, I think you would see it being appealed.
Gotcha.
So I think it's in everyone's best interest where possible to settle it. And I expect it will survive the motion to dismiss.
Right.
So that's our Peace Health case. And I know some folks that are our plaintiffs will be unhappy to hear that I said it's possibly in everyone's best interest to settle it. But you're talking years of protracted litigation and you're rolling the dice when you might be able to have a sure thing in hand. So, I mean, we'll see. Obviously, if the settlement offer, if we get one, is terrible, it's not going to be taken.
Right.
So that's that case. We've got several doctors' licensing cases that we're working on. We have Dr. Turner. We were just on the podcast with Steve Kirsch with him, practicing out here in Richland. And Dr. Lynn, who also practices here in Richland. And both those cases are still progressing forward. We're in the discovery element, which will close for Turner in January, and then for Lynn in February. And so we're still really in the preliminary workup, but that's where a lot of the rubber hits the road. We have thousands of pages of medical charts that Karen and Emily, who's one of our new attorneys, is reviewing. They're reviewing and then trying to draft discovery questions to the state on that. And, we're ready to go all in. I know in talking with Mr. Kirsch, he was really giddy about having an opportunity maybe to pitch over some ideas of what type of discovery we could request. And so there are all sorts of folks out there, Steve Kirsch's of the world, whether you're, a tech multimillionaire or billionaire, whatever he is, or, regular Joe on the couch. We do appreciate your ideas that you send out.
Yeah, definitely. And I know you mentioned that we need to put that on our socials, and we'll make that pitch right now. If you hear something, see something on a podcast, or there's so much out there right now going on in the world, so many different podcasts, and we know that these particular topics are being censored or outright, just ignored in the regular media. And so when someone's having success in this particular battle, we're not necessarily hearing about it. And so if you do hear about it, you hear someone's doing something that's different than what we're doing, or may have more information or evidence that'd be helpful, please share it with us, whether it be over our social media or directly at our email, info@silentmajorityfoundation.org. However you need to get a hold of us, you can even call our phone number on our website and leave a voicemail. We do check those. I know, apologies to some of those that we've taken a few days to get back to, but we do check our voicemails, and we actually just cleared it out, so there should be plenty of space to leave a message. So, yeah, if you hear anything, if you hear something, say something.
There you go. And if you do hear something, please don't say, "Hey, here's a 90 or 120-minute podcast." I mean, I'm sure all of the information is good, but try to give us a 5 to 10 minute window max. I mean, especially if it's 3 sentences. Keep it to that 5 minutes. Perfect example is Karen happened to be listening to a Dr. McCullough podcast with a doctor in Iowa. And this doctor's having the same issues that our doctors are having, prescription for treatment of COVID. And, he had hydroxychloroquine, not ivermectin, but it was the same issue. And we ended up connecting with him, and he's providing us great information that he's finding through his case. Now, I would love to sit and listen to Dr. McCullough's podcast. I'm sure I could be a much better prepared for everything that we're doing. I would love to listen to all the Kirsch's podcasts of the world, right? I don't have that time. It's not the luxury that we have. So again, to your point, if you hear something, say something, but try to give us a very abbreviated window, so we know directly where to go. And to that tune, if you hear something that really strikes you in your heart with our podcasts, please make a comment like, man, what you guys were talking at moment like 4 minutes and 30 seconds for a while. That was awesome. Can you snip that, right? And we'll do everything we can to work with our PR team. They're awesome. And get those snippets out there so that you can share a 30-second soundbite and with your friends and say, this is why SMF is cool. This is why what they're doing is great. I get it. No one wants to always go all in on a 90-minute podcast.
Right. I don't want to go on a 90-minute podcast today.
No, I mean, and so many of them have such great value. So yeah, that's kind of our call for action for now. But we certainly have a lot more cases to get through. Let's just stay on the doctor's licensing. We have Dr. Wilkinson's case. He was practicing in Yakima, or is practicing in Yakima, and had the same issue with ivermectin. And we had the hearing here earlier in the spring. He had a final order issued by the state of Washington Medical Commission. And then we appealed that to the Yakima County Superior Court. And then we agreed with the state that, this is a case that both sides are probably going to take to the state Supreme Court. So why not just fast track it and get it in the Court of Appeals? And I called the Superior Court in Yakima County, and they said that they transferred it earlier this week. So as soon as we have something out, we'll get a briefing schedule. Karen and I were working on a motion to stay the order, which means put a pause on compliance until the appellate court has a decision. And with that, we'll reassert the motion to stay for Dr. Wilkinson. But really, we're just sitting waiting on the appellate court to give us some sort of direction that it's actually received the packet, if you will, from the Superior Court. And then as far as the last licensing case, we still are working with Scott Miller's case. I know lots of folks were following that early on, and we're grateful for Scott and the work that he's done. And that case, we've appealed parts of his licensing order to the Superior Court in Clark County, which is where he practiced. And so that should be heard by mid-November. I think while I'm on vacation is actually that hearing. And so, we're appealing. Basically, they want him to undergo this mental, psychological evaluation ahead of getting a license out of state or reinstating his license or anything of that nature. And, we believe that under the law, it's required that they provide notice and a hearing on that specific issue. Well, when they ran it into the last day of closing arguments, there's no real meaningful opportunity to be heard on the issue, and it's not a standalone issue in the hearing. So I think we can have some success, which would really help Scott. Now he doesn't have to go to like crazy treatment basically in re-education camp. Because quite frankly, these doctors are obviously entrenched in the data and research they've combed. It just disagrees with the medical commission's data. So that's the specific to the licensing. Turner versus Washington Medical Commission is on behalf of Dr. Turner, Dr. Moon, Dr. Cole, and Dr. Wilkinson. We sued the Washington Medical Commission in Benton County Superior Court. The court issued what's called a stay of its own action, which I thought was kind of odd, where it's like, okay, I'm going to put a pause on my game, and we got to wait until there's a final order. Well, lo and behold, literally the week before the hearing, I think it was 10 days, Dr. Wilkinson got a final order from the Washington State Medical Commission, with his license and its impacts and his scheduling fees and all the other things that were associated with his final order. And, we put that in evidence to the court, and the court seemingly glossed over that and said, well, there's no final order, so we're going to stay this. And so we've appealed that decision on what's called discretionary review. It's not a final decision. It's just a temporary decision. And we're asking the appellate court to say, hey, you know what? We want the lower court to look back at this, especially in light of the Wilkinson issue, especially in light of the fact that we're challenging the position statement, the Washington Medical Commission's COVID misinformation position statement. we're not really challenging that in any other way than claiming it's a final order that violates free speech and the right to be treated as one would want, and right to treat as one should, offer treatment. And so we believe that the appeal there is going to be really, hopefully, attractive to the appellate court. We filed that appeal earlier this week, and we have to brief that here in the next 15 days, so 14 now. So we're going to do some heavy briefing. We're also looking at asking for an injunction, asking the court to stop enforcement of the position statement, at least as to those 4 doctors. And so, I think there's some potential success. We saw that Dr. Eggleston down in Asotin County got a temporary injunction to allow him to brief the issues. And that's the very same court that we're asking for discretionary review and potentially an injunction from. So that's moving forward. Again, you folks would have seen the Linebarger case. That was the in-ray recall of the 3 officers in the Spokane Liberty Lake, the school district members, a Central Valley School District. And we briefed up the fact that there is, in fact, a right to petition, and not just a right to petition under the Washington Constitution, an actual right to recall under Article 1, Section 33 and 34. And the fact that that was added to the Constitution shows that the near founders, because it came, I think, in 1911 or 1910, so within the first 50 years of the state's existence, it was added to the Constitution. Mm-hmm. So these kind of second generational founders saw it so important that they actually codified it in the Constitution, not in law, but in the Constitution itself. The effort to amend a Constitution is much more significant and much more of an uphill battle than it is to amend law. That happens every year. That's why we exist.
So just curiosity, I haven't done any research into this. Do you know what it takes? We know what it takes in the U.S. Constitution for an amendment. What does it take for the state Constitution? Do we know?
I don't know, to be honest. I didn't look at that. I probably should have before I said how difficult it was to amend. But
it doesn't happen very often, so it must be pretty difficult.
Right. And that's obviously something, if our listeners want to know, they can ping us and say, hey, why don't you guys look into that and get us some sort of information. Maybe we'll just put it out on socials. Here's what it takes to amend the state constitution.
Well, just with our cases, the Second Amendment cases that we have, you'd think that if it was an easy task, that they would just amend, Article 1, Section 24.
Yeah,
that states that
you have the right to bear arms unless we say otherwise.
Right.
That's probably the best catch-all phrase that the left could bring.
Yeah.
And I know we try to not veer into the left or right, but clearly from Olympia, it's the left that's pushing these gun bans.
Yeah.
I know that some of their supporters have cried out saying, no, we don't support it. And we understand that. We understand that there are individuals on both sides of the spectrum who both agree and disagree with us. But, it's those Democrat legislators who are pushing these bad bills.
Absolutely.
So
Absolutely.
Let's see. Make sure I don't miss anything. I guess just to wrap up on Linebarger, we filed an appellate brief, and the state has 2 weeks to reply, and by December 8th, there should be a decision on what that review looks like from the appellate court. And so I'm hoping that we'll see some really solid success there, because I think it's an important issue, not because Mr. Linebarger appealed through the recall process, but he was hit with a $25,000 fine for so doing. And the judge in Spokane County was just like, no biggie. We've seen failed recall efforts happen time and time again. We've seen failed recall efforts by the same groups and individuals, yet they're not punished. And Mr. Linebarger goes out, pays 2 attorneys to confirm his research. They sign the pleadings. They represent him in court, and he shows up in court, does everything he's supposed to. No, we want money. And that's how the school board operated, and that's really unfortunate. It certainly shows that maybe the recall should have succeeded of those 3.
Yeah, well, I'm not going to disagree there.
Yeah.
So,
go ahead.
Well, I was just going to say, so we've talked about the licensure of the the doctors and going. I kind of wanted to come a little bit back. You jumped right in Linebarger. I didn't get a chance to ask. Um, when we talk about that particular position statement, that they're enforcing, what other kind of issues could you foresee in the future if we weren't to continue to challenge this and to get that position statement removed? What other issues could you see foresee in the future happening to not only our doctors but anybody else that falls under the Washington Medical Commission?
Yeah, I mean, what you're going to see is continued adoption of regulation through illegal means. You know, the state may disagree with us, but there is no question that the position statement is being enforced. That means it is a rule. That means it needed to be adopted in a very specific manner. There had to be notice and comment, and then you submit it to an in-house like legislative service. When I say you, I mean the agency. Mm-hmm. The agency then submits it to the legislative services, and then it comes out in a pre-published, and typically there's still more comment period on the pre-published decision, whatever the rule is, and then there may even be a hearing or at least another meeting to adopt it, or it might go into effect on a date certain. But none of that happened here. In the case of the position statement, there was a 24-hour notice of a discussion, not an adoption, but a discussion. And then they voted, they adopted this rule. They used COVID as this kind of smoke and mirrors, cloak and dagger approach to say, hey, we've got to meet via Zoom. I don't know. There was just barely a quorum as far as I can tell. May not have even been. Mm-hmm. We've not pushed to subpoena the records or anything of that nature. But they had a vote at the end and they adopted this position statement. So that means to me that every time there's a reason to meet via Zoom, or if you've not let go of your, you agency have not let go of your pandemic Zoom attendance policy, then you're seriously looking at an opportunity for these agencies to pass these rules without really engaging in the process. That means that you and I are going to be bound to whatever's done, whether it's Department of Licensing, they say, okay, anyone that doesn't have a purple driver's license is now driving illegally. Well, no one, as far as I know, has a purple driver's license, but if they decide that's what they want to do, they could do it. 24-hour notice. They were discussing purple driver's license, vote and say all licenses shall be purple from day forward. So it's concerning at the least, because you and I, not only as doctors, but as patients, you and I have rights, and those rights were trampled without proper notice and comment for you and I to comment, not just the doctors whose licenses are impacted.
Right. Is there any chance that this position statement, had it gone unchecked, become a rule and become the status quo for how they operate?
Well, yeah, I mean, they still could have brought it through the process, ignored our complaints or our comments, and still adopted it within the proper standards and procedures. Now, that would have made it even more ripe for you and I to sue. I mean, we've talked about this. We've commented on rules that have really no bearing on the way you and I live, confined animal feed operations, stuff like that. Mm-hmm. But they do impact the way that we live, in the sense that we could buy those animals at a cheaper rate if they don't have such restrictive licensing or other regulations. So, when someone thinks, oh, it's no big deal, it's just kind of sped up the process. Like, this is significant. And you and I have the right to know what the agencies are doing. And in this case, the medical commission, was clearly not transparent. They sped the process. And had they gone through the process, yeah, again, maybe they adopt it without caring what you and I say, but at least we had the opportunity to say something.
Gotcha.
Goes back to hear something, say something, see something, say something. Well, see something and just sit idly by until we tell you what you're going to say.
Absolutely. Well, and it just seems like that's become the status quo at the state level here in Washington, that they adopt some kind of position statement or new rule or whatever, and it affects a certain subsegment of the population that really affects them, whether it be in their financial situation or their livelihood, or however they operate day to day. But the rest of us just kind of say, oh, it's okay, it's not bothering me, I'm not going to say anything about it. These are the rights, the property rights that we have, that we need to stand up for. and even if it's just a subsegment of our population, our fellow citizens, it's so important that we stand up and say, no, you're not going to just pick a rule and make their life miserable because I'm the next one you're going to do that to.
Yeah, I mean, the government overreach is so pervasive, that here we have administrative agency overreach and overgrowth where the executive is there to execute laws, not to adopt them, implement them, and enforce them. That's partially the legislature's job. That's partially the judiciary's job. But here you have an executive agency that just says this, so shall it be from day forward. Right. And that's extremely problematic. I mean, we're already struggling fighting our legislature on its bad laws. That's why we exist. We've covered our medical freedom elements, and obviously the big stuff that we're suing because of bad legislation is all of our firearms laws.
So, right, I'm glad you're getting into it because we just got a question from Rick Hartman. He's asking, any update on the Gimme Guns / Scott Brumback case regarding high capacity mags?
Okay, so I'll start there. I was going to go Gators, but we'll go. So to not dodge the question, we have 2 cases on the standard capacity magazines that exceed 10 rounds. One is in federal court in Eastern District of Washington, and that's the Gimme Guns Brumback versus State of Washington. That case, that was the one that I mentioned the judge held for several months. We had the hearing the day before Thanksgiving of last year. We got a decision on our preliminary injunction in September the 25th, if I'm correct. So a month and a half ago. And that order required us to come together with the opposing counsel, with the state and the Alliance for Gun Responsibility, which I don't believe certainly is an alliance, but not for gun responsibility. We had to get together, kind of knock heads and say, here's how we believe this case should be scheduled. Now, of course, Silent Majority Foundation believed that because this is a very important right, the right to bear arms is one that the individual must continue to have. We tried to brief this out as quickly as possible. I think we even tried to push it to the end of the year, meaning the end of 2023. We agreed that if it ever goes to trial, fine, 2025, no big deal, because I don't think this case goes to trial, to be honest. It's going to end up in a permanent injunction or a denial of, and then it gets appealed. Mm-hmm. Just like the Bonta case in the Ninth Circuit from California, which that one was an injunction that was issued. And in this case, hopefully we'll have the same issuance and the bad guys will also appeal it. Right. And so in the Brumback case, we had a scheduling hearing earlier this week, and we can get that out early next week on our socials. And in that scheduling order, the judge said, hey, look, I'm not going to, let me back up. The state wanted to push basically briefing out till I think next December, 2024, not this upcoming one. And, it's going to happen in like 28 days. I'm talking about in 2024. And the judge said, I'm not going to delay that long. I'm not going to delay that long. You guys need to have this briefed by March and April. And then you're going to need to have a hearing no later than early May. And I don't remember the date. I want to say May. It's either the 12th or the 21st. I think it's the 21st. But
you're talking about the Brumback case.
Yeah, the Brumback case.
So that schedule is posted online.
Is it?
Yeah, if they want to check, it's on our. If you go to our work and you go to the Brumback v. Ferguson case and click into the case documents, you can actually see those dates. So if you want to know exactly when we got to get what we got to get done, you'll see what that schedule looks like. And I think May 5th or 25th is what I recall.
May 21st at 10 a.m. It's on the whiteboard.
Get up there.
Like I said, I knew it was the 12th or 21st. My dyslexia was hit me. So anyway, that case will be heard May 5th, 5/21, May 21 of 2024 at 10 a.m. in Yakima in the federal court. It's kind of nicer than the other court. Certainly welcome to come out and visit. And I'm excited. I know people say, well, gee, you filed this last 4th of July. You're sitting just shy of 2 years. And yeah, it's tough. I mean, watching the Duncan v. Bonta and the Miller v. Bonta case, which have all gone from district court to Ninth Circuit, some activity in the Supreme Court, and then back down to the Ninth, and then back down to the circuit level, and then back up to the Ninth now. these cases are 5 to 7 years old.
Yeah.
And I obviously don't want ours to take that long, but I'm happy to know that we will have a hearing on a motion that will either dismiss the case or not. And it will be an appealable motion. And no matter what, it will get appealed, I'm sure.
Yeah.
Because if we get what we want, some sort of injunction, the state's not going to be happy with that. Unless we beat it, which I expect we will in Gators, which is also a challenge to the standard capacity magazine ban, which holds greater than 10 rounds. And that's the one where the state came in and issued a civil investigative demand, which is basically a tool saying, under penalty of perjury, tell us how many magazines you sold, in contrary to this law. We challenged that on behalf of Gators. There were lots of arguments back and forth, and eventually the state dismissed it because they decided to come in and sue Gators. Now, this is critical. They sued Gators in Gators' home county, which is the only place they could sue them, which is Cowlitz County. Anyone that knows anything about Washington State, that's neither King nor Thurston County. And those are your two most compelling points. It's neither of those two counties. And we had a hearing about a month ago on, and basically our position was, Your Honor, do what you want to do. If you want to consolidate the two cases, so be it. We don't really care about the civil investigative demand. The state's dismissed it. They've given us a letter. We should post that on as one of the wins at some point. They dismissed it. They gave us a letter. And really all we care about is whether or not this is constitutional. If it's constitutional, our guy is going to have to get hit with whatever penalty if he actually sold magazines is alleged. If it's not constitutional, get the hell out of here, state. And the judge in that decision, in that oral ruling, like directly from the bench, he's like, I want to know, is this constitutional? That's all I want to know before you guys do anything else. And the state has now agreed. There was a bunch of discovery we were supposed to have to answer to. The state's agreed to stay discovery. We could have asked discovery too. All Austin and I are doing now is focusing on the single question: is 5078, the ban, the magazine ban, constitutional or not? And our position is this should. We had a briefing schedule that the state offered that would have had us briefing as of today. But because of everything else we had flying, we pushed it out a week. And then the state brought in more attorneys. And as those attorneys got involved, then it turned into 2025. And then it turned into, okay, we'll concede and go to summer of 24. And then the Brombach thing was pushed and it was May 2024. It's like, well, we should track this with Brombach. And it's like, well, Brombach has specifically asked for expert witnesses. We don't necessarily need them in this case. And even if we do, come on, guys, you're just dragging your feet.
Right.
And so we have a hearing on the 8th, which is Tuesday, Wednesday, sometime middle of next week, in front of the same judge, where we've honestly gotten to the point where we've sent back and forth emails, and we've sent those into the judge saying we cannot agree on a schedule. Ideally, it's like your two kids, stop fighting in the back seat. I'm going to separate you. You separate them. They stop fighting. Well, just like your kids, that didn't happen. Right. We're still fighting. Yeah. And the state wants to push it out. And we're like, hey, we want to have a hearing before Christmas. We believe we can get the work done and get it done competently. We've briefed these issues in Federal Way Discount Guns. We're no longer representing them. We briefed these issues in House Bill 1240. We'll talk about that. House Bill 1705. We'll talk about that. And with some of the briefing we've done in Brombach and some of the other ancillary briefing, plus all the research that we have. And don't tell me the state somehow is missing something.
Right.
They can go cherry pick what they want from California, Oregon, or any other.
Well, and not to mention that we got the decision from Benitez on the exact same issue.
Yep. So we've got plenty. Both parties have plenty of information. So there's no lack of resources. It's simply the will. And in this case, because we knew that Brombach was pushed out, and I got to say, the judge was very clear. I don't want to push this to the end of the year. She said, she owned that she had kind of delayed on her issuing her order. She owned that, which I thought was great. It's not as great as getting it quickly.
Right.
But at least she owned it, and she said, I played my part in that. I don't want to wait this long there. And the state always pulls, oh, well, this other case, this other judge. I'm like, dude, you're not talking to the other judge, man. You're not. Just deal with what you've got. And the state really doesn't like to be told no. And I really think that this constitutional question in Cowlitz County is really setting the stage for everything that really matters.
Right.
And notice one other thing to notice is that the Oregon Measure 114 case, now we know that was a bad decision out of the federal court, but the state court is supposed to issue its decision in sometime in the next 2 to 3 weeks.
Yeah.
No later than the end of the month is what's projected. I don't know whether they have a law like Washington does where a state court has, I think, 90 days with a potential extension. Regardless, Measure 114, which is a pure state constitutional question in Oregon, and there's great case law where we cite to Oregon's constitution because guess what? Our founders ripped theirs and improved it where they could.
Right.
They didn't make it worse. They improved it. So there's great case law. It's like, hey, look to Oregon, right? Especially for the right to bear arms.
Yeah.
And so I think all these tea leaves, they align, and we might be able to get even stronger, to your point, with Benitez having issued his decisions, with 114, Judge, I think Raskio is his name, potentially having an order and a decision that we can borrow from. I mean, I think we can do this. The state, of course, really wants to push out experts and all this crap. And it's like, dude, we went to law school. We've all been practicing attorneys. Why do we need an expert to tell us what history says? Like, we can read freaking books. I mean, if you were to ask me, like, what's the velocity of XYZ gun and XYZ particular ammunition, and how quickly does, the magazine allow whatever, right? Like, yeah, I can't tell you the science of that. We'd want a gun manufacturer.
Yeah.
But
that doesn't matter.
That doesn't matter. What matters is the Constitution. So I know that's a long-winded thing. I'm super excited about Gators, if you can't tell. I'm really excited that Brumback, I think, is turning the right way too. So those are the two standard capacity magazine challenges. Now, to House Bill 1240, which was the so-called assault weapons ban, I would give it some other nickname, but there were like 72 different firearms banned under this allegation that they're assault weapons. Maybe it's the mean and scary gun ban. I don't know what we want to call it. That case, it was started in Grant County, moved to Thurston County, and we really, 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 really wanted to challenge the move to Thurston County and keep it in Grant. Mm-hmm. But because, quite frankly, we didn't think we were going to be so far underwater in this case and so far delayed in it, we really thought that the right decision was to allow it to play out in Thurston County. And, of course, our injunction was denied. The preliminary and a temporary restraining order and the preliminary injunction were both denied. Now the state's seeking discovery. They're going to try to compel discovery. We think they've gone very, very far beyond their fingertips with what they're asking. They're asking for your information. And when I say yours, not yours or mine, but the donors. They're asking for information of records. They want correspondence from the declaration emails. I mean, stuff like that just really reaches in. What type of guns does everybody own? What does that matter? What does it matter? The question is whether or not it's legal to impose a ban on purchasing certain firearms, not to continually maintain them and retain them. So anyway, that case, we did an emergency appeal to the state Supreme Court. And obviously, if the state Supreme Court briefing will be completed by mid-December, and they have to have a decision, I believe the commissioner will decide whether or not the Supreme Court's actually going to hear the case, and which would require more briefing by December 8th. So that's moving along. We are obviously protecting all the records that they're seeking. There are some that we provided that were generic or were specific to our vendor plaintiffs. Mm-hmm. But we're not providing a list of firearms. We're not providing a list of people who emailed, and we're certainly not providing a list of correspondence or any correspondence. It's not appropriate.
Right.
They redact their stuff all the time. So, we're not going to be doing that. So they'll file a motion to compel, and we'll have to deal with that. It's just more make work thanks to the state. That's your tax dollars hard at work trying to make sure that you are discovered, that you are put out in the crosshairs when Bob Ferguson, continues to infringe on your rights. So that's 1240. I'm a little fired up because, the state's it's not reasonable, the discovery requests.
Yeah.
So that's that case. And again, I think the Supreme Court's going to give us some good guidance on that. I expect that early December, about 5 weeks from now, we'll have a case that they want to hear, because this, again, is a pure constitutional issue. So we don't need experts.
Right. It's funny to me because if they truly believe they had a good case, they would be wanting to go as fast as they could.
Exactly.
They'd be pushing us as hard as we could, because it goes both ways. You drag it out, it taxes our resources. You go fast, it taxes our resources. So they obviously know they don't have the right on their side.
Yep.
The question is, can they position themselves with the right judges in the right time frame? Can they give themselves enough time to get in that position, or hopefully wait us out?
Yeah. And, we're not going anywhere. I know we've talked about the need for funding, and I'll make a pitch for that. Like, we absolutely need funding to make sure that our heads are above water. You'll see emails and texts come out about Giving Tuesday and other campaigns that we're pushing over the next several months, because we really do want to make sure that we're secure in our funding to secure your rights. This isn't just about, oh, hey, we want to make money. This is making sure that our awesome staff, we are blessed to have 3 attorneys full-time on this, and we've got a volunteer attorney who's interested, and we've got several other folks interested in joining. We've got you running the show. We've got the PR team. We've got, PJ doing the donor relations. We've got people that are either volunteering a significant chunk of their time or professionally doing this to make sure that we stay a well-oiled machine. We're not the state. We don't have tax dollars coming in regardless of whether or not you and I can afford it. And we don't have the resources of 100 plus years of having an agency where I could literally go to a shelf and be like, oh, I'm sure it's all digitized now, but what was the case like in 1984? Oh, let's look gun right. But they can do this stuff. And guess what? They have paralegals and support staff to do it for them.
Right.
I got a PRA request, and it was like, very clearly the support staff had done something, and there was this kudos email like in the middle of the PRA. And nice work. I can't remember the person's name. Nice work, and I recognize it as the paralegal.
Right.
Anyway, so yeah, that's 1240. It's moving forward. We can back to the, we definitely could use donations.
Yeah.
That's where that is. Last gun case is House Bill 1705, which is the so-called ghost gun case brought in Stevens County. And just like Grant County, that case got moved to Thurston County Superior Court. In the interim, we did get the Doe plaintiff, the motion for pseudonymity. Crap, I can't say it anymore.
Pseudonymity.
For our plaintiffs to be
Pseudonymous.
Our people to not have their names displayed. I am so glad Austin argued that one. That would have been rough for me. I don't know why I can't say. Anyway, it doesn't matter. Our 3 plaintiffs, our John Doe plaintiffs, are 1, 3, and 5, and they retained status of unnamed.
Anonymity.
Yeah.
Anonymity.
Yeah, see, you can't say anonymity. We're a perfect team here. No pseudonyms and no anonyms. So anyway, that case is out of Grant County. And when it got moved to Thurston County, we said, okay, this case doesn't impact my ability or the gun, the FFLs. We've talked to so many FFLs who are either hemorrhaging terribly or quite frankly have rolled up because of 5078, the magazine ban, or because of 1240, the so-called assault weapons ban. That's why we had to fast track those. We knew people would lose their livelihoods. With 1705, it's really, do you own a gun that's unstamped, and are you going to comply with it, right?
Yeah.
That is a very personal property, and no one in their right mind is going to say, oh, hey, that's me. And we are
should they.
certainly, yeah,
should
and
they.
we are certainly never going to allow for discovery on that question. How many ghost guns do you have? Doesn't matter. Get the hell out of here, state.
Ghosts don't exist.
Yeah, right? Phantasmic guns.
You're crazy.
Yeah, I mean, Halloween's over, man. Anyway, that case got transferred to Thurston, and we said, okay, this case doesn't have to be hammered right now. So we can delay it, and really, it's not really being enforced. And even if it were, how would anyone know?
Well, there is one. We have been contacted by one manufacturer that does manufacture
True.
the
Non-serialized.
non-serialized or incomplete lowers for resale or wholesale, and they're struggling because that part of their business had to be rolled up completely. Other than that, though, they're doing fine. But to your point, it generally is someone that has their own manufacturer capabilities and produces or creates their own gun. And now that's a whole different technology that's really come out, is the printing, plastic printing or metal printing, where you can actually print your own pieces and parts, which is I think phenomenal for us as a people. I mean, really, just to think of the innovation that we could come up with, especially because manufacturing had been shipped overseas for so long. Now, if you can bring manufacturing not just back to the U.S. but into people's personal homes, or just the small business, so the small business industry should be booming right now. But the federal and state governments are doing a fine job of making sure that people can't provide for themselves.
Yeah, there's nothing better than a completely subservient people when you take away their right to do everything that's been protected by God and the founders, and you try to play that role of God. I mean, there's no surprise that we're having righteous judgment against this country.
Right.
I mean, it's hard to see. I love it. I will never turn my back on it. I will never say that it's nothing but special. But when the people in charge are that wicked and evil, the people suffer.
Right.
So back to, turning from righteousness to ghosts, our ghost gun case. So it's in Thurston County, and we appealed to the state appellate court, Division 3, which is on the east side. We've had briefing, we've had oral arguments, and we expected, probably 2 to 3 weeks ago, a decision so you argue in front of a commissioner who then basically is the gatekeeper. In this case, is she will take it back and say, hey, this is what I think, you guys should hear this case, or you guys shouldn't. Here's why, here's my analysis, and here's my opinion in order. And then, she'll issue it. And so we expected, because this argument happened, I think, in August, we expected to see this decision from the commissioner no later than 2 to 3 weeks ago. Again, this goes back to one of your questions. What do I expect? Again, I'm looking for an opinion any day to tell us whether or not we're proceeding, because that is a critical question as to the state. Every time some sort of statewide decision's made, in this case by the legislature, they try to use the whole Jay Inslee emergency powers and ship it to Thurston County. Well, you're suing a state official in his capacity. And yeah, but suing Jay Inslee because he made an executive decision is different than trying to invalidate an unconstitutional law that was adopted and approved and, debated by our legislature. And the state argues, well, Jay Inslee, and he doesn't have enforcement authority. He doesn't. Bob Ferguson may have some limited. That only happens if the county prosecutor fails his or her job. So there's really no particular individual involved. And we've argued that. Now, we named them early on, and then we modified the complaint to show that really they have no standing here. So I think it's going to be an interesting case, and that could really impact, this would impact no different 1240. We sued the state of Washington. This would bring that back to Grant County, theoretically. Now, we're probably too far down the road to do that, especially with having petitioned the Supreme Court. But if 1705 is successful in saying, no, this needs to stay in Stevens County, we're going to get a great order out of this appellate court, right underneath the Supreme Court. And I expect that we'll see the state appeal this to the Supreme Court. But, that could be a huge win for the people of Washington, that they don't have to go sue the state of Washington in Thurston County. They can sue it in their Cowlitz counties or Stevens counties of the world. So I'm excited. I mean, we have a lot of great work, and it's not just these very core fundamental personal rights of right to bear arms and free speech, but they have these really broad, entangled legal principles and theories that are going to impact the way the state operates. And I mean, we're very fortunate to be blessed with attorneys that see that, and that's like, no, I got to take this exit ramp on this case because it's going to impact these 2 to 3 to 4 rights. Or I got to get over here. I'm going to merge into this lane, right? Like, it's awesome that we're not just like, oh, well, it's not Article 1, Section 5, so it's not free speech, and it's not Article 1, Section 24, so it's not right to bear arms, so I don't know what to do with it. Like, we get creative, we get innovative, and I think that's where the state really hates us, because it's like they march to the state drum.
Mm-hmm.
And which is sad because they have so many resources. Like, imagine what that could do doing good.
Right.
That would be amazing.
It would be.
So
to your point about earlier, we had the one unless Gators goes through. The other unless is if we get an AG in office that is actually constitutionally minded.
Yeah, and I mean, I think I always say this, I think this is the year to make it happen. It's the tea leaves are there. Obviously, Bob Ferguson is running for governor. I guess Jay Inslee could pull the rug out and say, nah, I'm staying here. It seems like he's really decided that's not the case.
Right.
Based on, we've talked about this, his trips overseas and stuff like that. And Ferguson has like very clearly pushed, like, this is what I'm doing. You have Hillary France that's taken out her seat. You have a lot of folks that are up at the top that you could see some change.
Yeah.
You got some great candidates. I'm excited to see how Semi Bird and Dave Reichert arm wrestle over who the Republican side of governor is. We know Semi very well. We don't know Mr. Reichert well, but he's certainly got one heck of a resume. He's won up in King County several times. And, there's a lot to that. And back to knowing Semi, we know his principles and his values. Right. So
speaking of Semi, if you guys would like to have Semi on the podcast and talk with us, let us know. Shoot us a message or say, hey, that sounds like a good idea. We've asked him. He's open to the idea of coming on the podcast. So you guys think it'd be great to have him come and talk Constitution with us and his opinions on that, and that'd be great. So let us know what your thoughts are on that. But
yeah, same thing with Mr. Reichert. We don't happen to have a direct contact, and to be honest, anyone that's listening from the other side of the aisle, I'm happy to talk to Hillary France or to Bob Ferguson. One of those we sue a lot. But you know what? If he wants to come in and have the conversation, we believe that there's a right to trial by jury, right? And so I have no opposition to sitting down and talking with Mr. Ferguson and just saying, hey, okay, we've sued you on these bases. What are you going to do as governor to protect these rights? Oh, well, they're not rights. Well, then explain that. You're a lawyer. I'm a lawyer, right? Like, let's hash this out.
Yeah. Defend your positions.
Yeah. So... No, we've got a lot of work that covers really kind of the most critical work. We're local counsel on another half a dozen cases, which means we're kind of lightly involved. The Feds for Medical Freedom are up there in Bremerton at the shipyard suing the pants off of the agency folks, Mayorkas and crew, involved in not but one but two lawsuits up there as local counsel. Got some other ones where it's individuals and groups suing the state of Washington. So I think there's a lot of work that we're really in not over our heads, and that we're not competent, but just like buried in work. And then there's work that we're kind of peripherally involved, making sure that other good attorneys from other states are able to come in and practice through our sponsorship. And I'm proud to grow that field because, the Washington attorneys who are taking these cases on are few and far between. We've, shouted out our friend Nate Arnold, and we know that his organization has like 9 or 10 mandate lawsuits. They're moving along, and they've actually come back and said, hey, maybe you guys could help us. We took on a ton of work here. And so where we can, we'll help. And that's what we're all about, is partnering to protect your rights. We'll do it on our own when we have to, and we'll do it as a partner when we can.
Absolutely. Now we're coming up on an hour. We're at 55 minutes right now. I know we're supposed to go half an hour or less, so we've obviously overshot that. But the one topic we really haven't hit on was our case out of Florida. Did you want to go on that today, or?
Yeah. I thanks for not letting me overlook that. So yeah, we partnered with, back to the point of partnering with out-of-state friends. We met Rachel Rodriguez of the Various Law Group and her staff at the COVID litigation conference sponsored by Vaccine Research Safety Foundation, Steve Kirsch's organization, and the Mendenhall Law Group out of Ohio. And, Rachel has a tremendous passion for individual rights too. She just happens to operate a commercial law firm in South Florida. And she approached us and said, hey, look, we are going to file a document with the Attorney General of the state of Florida and seek criminal investigation on Fauci and friends, Fauci, Birx, Walensky. I can't remember the other couple offhand, but we're going to seek criminal investigations of that. And so they wrote up this wonderful 20+ page brief of like, here are the laws that we believe, like murder in the second, we believe that they've actually violated, because here are 32 people who died. And obviously there were way more than 32, but here are 32 family members who are willing to tell the story of their deceased. And so she says, I'm going to send it out, and to the extent that SMF wants to partner, I'm happy to have that. And then we'll get it out to other states. I said, well, let's not bring it to Washington because we know how that'll be received, right to the shredder. But, to the extent that we have contacts in other states, other attorneys general who are willing to potentially investigate this, we're going to work with it. And so, maybe it's fortuitous that we found this gentleman, this doctor out of Iowa that we talked to today, and we can get to the attorney general through him. I don't know. As of right now, it sounds like the attorney general's office is kind of pointing fingers saying, oh, no, it's, this way is that way, and you got to talk to this person. So next step is they have their special prosecutor for their existing grand jury investigation that's based on the shot. And we're going to reach out to Mr. Cox is his name. We're going to reach out to Mr. Cox, the special prosecutor, and say, hey, can you do anything with this info? Assuming that goes on deaf ears, we're going to reach out to DeSantis and his attorney, who are the two that initially filed charges asking the Supreme Court to engage in the existing grand jury, which goes through the end of the year and can be extended a little bit longer. We also believe that the fact that Donald Trump is a resident of Florida, there's value in maybe getting the information in the Trump camp, and we've done what we can to provide it to the Kennedy camp. And so I believe that with 2024 coming up, people are like, well, this is a health issue, and I agree 100%, but it's been made a political issue. And quite frankly, that's been the leading edge of how this has been mismanaged. And so with that, we need to utilize our political assets and allies to push this through. I mean, it's sad. Mm-hmm. People died. It should just be, hey, here's evidence, go investigate. But that's not the political appetite that most folks have. So, hopefully we can get some traction there. Again, look, if anyone happens to know an attorney general or someone in their office in a like-minded state, not to Washington, but us, right. Feel free to shoot us that contact at the info@silentmajorityfoundation.org. Send us resources. If you're like, hey, and we're well aware of thousands of deaths, and we've got some colleagues who have been tracking those. So while you're welcome to add, someone that that died in a certain state, that's not going to be as helpful as, again, a warm contact into that attorney general, that investigatory office, or certainly anyone that's got evidence or data that they may think we've either overlooked or not seen. Happy to do that. Or if someone practices criminal law in one of those like-minded states, it's like, hey, here are the 6 charges I would have brought.
Right.
Send it to us and tell us how to get connected to the AG. I'm excited about that, because this may be one of the few opportunities we have to strike into criminal charges, which everybody's been, well, not everybody that's like-minded with us has been asking for well over 2-3 years.
Yeah. Well, and from being here from the beginning, it was so frustrating seeing seeing the evidence that we saw, or just seeing the things that were obvious to us from our vantage point, and not being able to do anything about it. And that was a pill I had to swallow. As far as, well, legally, it's really hard to do anything in the courts unless you actually already have damages. There has to be damage in order for us to sue or do anything. Not the only way to do things, but if you're really going to be able to punish or make right or whole, the damages have to be obvious, and the evidence has to bear that out.
Yeah, it's unfortunate that you can't bring something that's a little more speculative, or that is well founded but not fully vetted. And there are opportunities to do that, but clearly the courts weren't interested in hearing those. Yeah. And those are the decisions we saw early on. But it's taken almost 3 years into this thing, 2+, and we may actually have a shot at justice. And so for those who are out there supporting our work, keep praying that Miss Moody is interested in moving on this activity, and that, what we've brought is compelling, but she'll see it as compelling.
Definitely. Cool. I think we hit everything, unless there's something else I'm not seeing up there.
No, I think those are really the prime real estate, if you will. We've had a ton of cases that we've dealt with in the past that are no longer live. We could always talk about that on a cleanup show, but these are the ones that are pressing. So just kind of to reiterate, the whole purpose of this was to let segments of our audience, of our donors, of our supporters know that we're not giving up on X, Y, or Z fight. Our messaging may seem cyclical, and maybe that's because we have deadlines in certain cases that just line up. It's not that we're losing focus on the firearms, or that we're losing focus on free speech or religious restitution or medical freedom. It's just sometimes the focus of our cases and the bulk of our work is spent in one particular area because of those deadlines. So, of course, we're going to shout that out a lot more. It's nicer to send you a product than a scheduling order.
Right.
Like, hey, we put a lot of hours into this 40-page motion, and versus here's a 1-page scheduling order that the judge wrote, right? Like, I mean, to me, all are very important in our work, and it shows that our work is moving along. But there's the real authenticity of what we're doing. Right. And I love to showcase that, because I'm extremely proud of the work that we're doing as a foundation. And that doesn't even talk about our advocacy. I can't tell you how many hours you or I spend with people, informing them of our work, informing them of how to assert their rights. That's not lost on me. It's just, to do a podcast on that, then we'd actually have to go back through our phone records, go back through our emails, and say, oh, these are the people that we've helped one-on-one, because there are many, many, many of those, and they don't make the limelight because they're not involved in a lawsuit, and the lawsuit's a lot easier to showcase.
Right. Absolutely. Well, and in a response email I sent out today to a gentleman that was asking, wait, I see all this medical stuff. What's going on with, or I think actually it was about the petition issue out in Spokane with Linebarger. What's going on with this? Is this what you guys are doing going forward, or you done the Second Amendment stuff? And my response to him was, look, our founding fathers understood just how nuanced keeping your liberty and freedom was, and they made it very obvious in the documents in the Constitution, the Bill of Rights. And if they hadn't made it so nuanced, we wouldn't enjoy the freedoms that we have. Now, unfortunately, it takes a nuanced and layered fight in order to maintain those rights. And there are lots of organizations that are really good at picking their niche, and that are just about Second Amendment, or just about religious freedom, or just about whatever thing they want to. And actually, I was at a conference this week with a bunch of those organizations. And my comment to them was, hey, I'm amongst my people. All of your fights are righteous fights, and I love what you're doing. But our organization has created a mission statement that is purposely broad enough so that we can be that umbrella which all of you fall under, so that we can be those safeguards of those rights. And that's really what the intention of this foundation was, is that there's that organization that says all the rights matter. all those rights that were endowed to us by our Creator, our God, are integrally important for each and every one of us to be able to live with the freedom and the life that we're supposed to. And that was, that was just a little taste of what I was able to give to him. And then, of course, I went into the 4 different live cases we have on the Second Amendment and told him that they are very much at the forefront of what we're doing. But I just didn't want that point to be lost on that gentleman, that, look, Second Amendment is very important, and we're grateful for your support and your money in that effort. But let me tell you what, we lose that First Amendment, that Second Amendment isn't as important. Well, maybe because we lose the First Amendment, we lose the Second Amendment too, or maybe vice versa. If we lose the Second Amendment, we lose the First Amendment. They both support each other. And that's really where we want that message to go, is that we are fighting for all of our rights.
Absolutely. And it's everybody's rights. I know we've been pegged as XYZ hate group, and, that's not the case. When you look at specifically that Dayton library case, it wasn't that we disliked the library or the librarian, but there is a right to petition that's constitutionally provided, and that organization that brought the petition to the local people, that it actually succeeded in getting the adequate signatures, had advice, interpretation of statute from the Attorney General's office that said, yeah, this is how you do it. And so, we're not picking sides. We are siding with the Constitution. If you misinterpret it, that's on you. If anyone questions, it shouldn't be that hard to figure out. We're pretty much originalists, falling in the Scalia and Clarence Thomas camp. And we believe that the founders intentionally created a protective shield around this nation through the Constitution. But for that, we'd just be another country.
Right.
And quite frankly, we probably wouldn't have survived as a country, especially through the Civil War and especially through other, civil rights movements, things like that really, and quite frankly, COVID might have done it.
And expanding to 50 states and all the different personalities.
And we could be that.
Yeah.
But we're not. We are the United States of America, bound together by the Constitution. And that really is the glue that sticks us together, no matter what our differences are. I may really dislike what people say. I may even dislike the people. But at the end of the day, they're my fellow countrymen, and they have the right to say, up to a certain point and do certain things. And we have to defend that right. Now, there are certain ways where it infringes and encroaches on your and my rights. That's where there's a hard stop that says, no, your behavior must stop. Whether it's a legislature, an individual, or whatever, we draw the line here.
Right.
And we will sue you for infringing on those rights.
Absolutely. I like to remember or remind myself the fact that, another individual trying to take my rights is absolutely obvious to anybody that witnesses that it's incredibly wrong and criminal. For some reason, we forget that when the government does the same thing, when the government tries to take my individual rights, it is absolutely criminal and wrong. And we need to push back as hard, if not harder, when it's the government trying to take our individual rights.
Absolutely. So. That's a great place to wrap up, because I know we're well over time.
Yeah, I like it. Great. Thanks for the update, Pete. I feel like I'm a little bit better versed in what we're doing, and I hope everybody listening is as well. Our good friend Adriana Amaya says, hello, fam. God bless.
Hey, we miss you. We hope all's well. We're praying for you and for your family.
So thanks for listening, and hope you have a good weekend. Any last words, Pete?
No, I think we covered it. The Constitution is the umbrella that protects us from the rainy weather we might be entering into.
All right. Hey, thanks for listening on, and we'll catch you next time.